Hello and welcome everyone to this webinar with our wonderful sponsors, the American Arbitration Association and, of course, the iTech Law Association. Our presenters today are Aaron Gatif, the Regional Vice President of the American Arbitration Association's Commercial Division for California, and David Coher, a mediator and arbitrator and founder of Coher ADR. And they will be presenting this webinar. If there are any questions, feel free to put it in the chat and I'll collect them for our hosts at the end or when there's room for questions. And as a reminder, this meeting is being recorded and will be available after the webinar concludes today. And I will gladly pass the mic to our wonderful hosts.
Well, thank you so much for the introduction today. I should also mention that in addition to being an attorney, David, you're a certified information security professional, correct?
That is correct. Thank you, Aaron. Yes.
So if there's anybody here that knows about information security and how it intersects with the law, it's going to be David. But David, I'll let you start. Take it away.
All right, great. Well, let's go ahead and jump through the slides here. Aaron, do you want to talk a little bit about yourself for folks here?
Just very quickly, the introduction kind of summarized it up. I am Regional Vice President of AAA's Commercial Division for California. I am the co-chair for AAA's technology practice, and then the national chair for AAA's entertainment practice. I hold a number of positions on the ABA SciTech section, including I am the chair of the popular podcast, which we just recently launched. Member of the ADR committee for the California Lawyers Association, and I also host a podcast for the ABA dispute resolution section called Resolutions.
Great. And then, as mentioned, I hold a CISSP certification, also an arbitrator with the AAA on several panels. I am an attorney here in California, formerly head of cybersecurity for Southern California Edison in a past life, and we'll get into some of that later. So let's go ahead and jump in here. Just a quick overview of our agenda. We're going to talk about the impacts of AI, how it has been really transforming the legal space in many ways, where some of the key concerns are about privacy and what to watch for, some case studies of some issues that have popped up in the news that you may have heard about, some background on those. Aaron will also be chiming in, telling us a little bit about what we can be doing, how to bear this in mind in the context of AAA arbitrations. And then beyond, we're going to talk about some action points, things that we can all be doing to consider as participants in arbitrations or arbitrators. So with that, I'll go ahead and move on here. So I won't read the slides for everyone, but I will note, I think everyone is aware of AI and its impact in the legal field, despite as much as you may have seen or not seen in your daily practice or activities. There's more to come. There are a variety of statistics that can be cited in terms of the expectations and the growth of the legal tech field. One interesting tidbit here at the bottom, ChatGPT recently passed the Arizona bar exam. And I think that's interesting when you think about what the bar exam is and you think about what's being tested for. That's really the kind of thing that large language models excel at. And that's so the question is going to become more of what is it that attorneys are doing? What is it that arbitrators are doing? What is the human element that's being added to the process? All right, I'll talk a little bit about some of the particulars, and Aaron, feel free to jump in as I'm going here. But it really is touching on all sides in the arbitration process. So, for example, you will see how parties are using AI. Obviously, they're using it in their actual business, separate from the legal endeavors, but in terms of legal work, contract analysis and review, There's a variety of systems out there that could result in folks providing the data, the underlying data to a system if it's not a closed system. That can create a variety of issues for both the parties and for the confidentiality provisions that were required under the underlying contracts and where that arbitration may have been agreed to. Also, obviously, using LLMs, we're going to mention ChatGPT a lot here, but I think understand that to be a placeholder for there's several different brands out there, obviously, competing for dominance in the space. But those LLMs are often used for strategic brainstorming. And by doing that, you can be putting facts into the prompts that may be open if it's not in a closed system. Attorneys obviously are using LLMs as well. There's a variety of targeted products listed here, as you can see. And these are designed for a variety of tasks, whether it's drafting legal documents, summarizing discovery, pulling that all together. Relationship mapping can be interesting understanding. But again, there's risks around both the retention of the prompts of that information that's provided as a part of the prompt. And also, there may or may not be clarity on the data handling. What are the terms? What are the companies that are providing these tools allowing you to do with that data? And what are they allowed to do with the data well beyond, right? So
And,
just
and I
something to keep in mind.
And I
Yeah,
just
go ahead.
wanted to add to that for the use by counsel, it's really important to note that Clearbrief, Harvey, Spellbook, Lexis AI, Westlaw, Edge, Paxton, etc. These are primarily closed source systems when it comes to using AI in legal work, which adds a degree of protection and a degree of safety right there. It's not simply throwing your inquiries into the free version of ChatGPT or something like that, of which you really have no control over where that information goes or what it's used for. And at AAA, we were concerned enough about our panelists using open source AI tools that we purchased a subscription to Clearbrief for every single one of our many thousands of panelists. And Clearbrief again is a closed system. It's a closed network, not open network, and the only universe of information it can search is what's already been programmed into it. So all those cases and things like that, therefore reducing the risk of, let's say, a hallucination where a fake case or a fake case citation is created, as we've seen in the headlines here in the United States. Go ahead, David.
Yeah. Thanks, Aaron. No, it's a good point. And I think it's something that requires regular diligence, shall we say, on the tools that you're using. Obviously, there's some that are going to be vetted more carefully, such as Clearbrief, it's being provided to you by the AAA. And I'm not trying to say any of the names that you see up here are necessarily bad products by any stretch. It's about understanding of the product and understanding of how you're using it too. Um, let's moving on, talking about document review platforms. Very useful tools. AI is a great innovation to a lot of these tools that really the next generation of document review through the computer. But again, you have to have an understanding and appreciation of what both the rights that the company has with it. Usually, those are products that are going to be more because they're being targeted towards legal workers. They're going to be more focused on those privacy concerns. There, it starts to get into what are the settings and how do you have it set up. So that, how open is it across, if you have a firm, let's say you have a large firm that you're working in, how open are the documents if you have some type of ethical firewalls that are set up, how are those implemented, right? To making sure that they're implemented across the board. Also, there is some use by arbitrators. I have spoken with some just anecdotal conversations of folks have played with the use for understanding drafting decisions, assistance in that space. I think this is something as an arbitrator you got to be very careful with. As Aaron's going to talk a little bit more in depth about later on, the job as an arbitrator is not to craft a good prompt or it's about to bring that judgment to bear, and that's part of what the arbitrators value to the process. Uh, but again, these tools can be used in a variety of ways. It may be used just to polish up a draft. That of course gets into issues about, well, what are you sharing in that rough draft? What kind of confidential information? What are the boundaries that you've set on the use of that data? So it's something to be very, very mindful of when using it for such purposes. And then you have a number of other systems out there that have AI features built in, and it's all kinds of products. It seems like every app on my phone, every website I use is offering some kind of AI feature. How AI it is or not may be up for debate, and the value add may be up for debate. But what you have to be mindful of is because AI is being embedded as a feature into everything, an understanding of what's going on with that and who's using that. If you have a program that's managing your finances for your personal or your firm, for example, you may not be consciously thinking about, you know, what are the settings for the AI in that software. But if it's providing information about payments that you're receiving, for example, from clients or money that's going into the client trust account, for example, that could be information that's confidential and something that may not necessarily be as obvious as your direct legal tools that you're using. Okay. Aaron, any further thoughts on this or?
Well, just on the ODR platforms and AI features, you listed off some things here, Turbo, Court, Madura, and Crack. So at the American Arbitration Association, you probably heard a few weeks ago, we issued a press release. We've developed a groundbreaking new AI arbitrator. Um, right now, it's not entirely AI. The AI initially goes through the first part of the process, but before any award is actually issued, there is a human arbitrator on the back end that's actually reviewing the award. We're beta testing it right now with what we call documents only construction claims under a certain dollar threshold. We chose documents only construction claims because they tend to have similar fact patterns, and we have a large database of prior awards that we could train our AI model on. I have included a little bit, sorry, here, a link here in the chat. Did that go out, David? I couldn't tell.
It does look like the chat there. Yeah, let me check. Yes.
Okay. Just a podcast episode I did for the SciTech Lawyer Perspective with our president and CEO, Bridget McCormick, discussing the new AI arbitrator and how it works and why it was developed, if anybody wants to learn more about it. Um, you know, the adoption of a lot of these AI tools, especially AI decision-making tools, people think it's the future, but a lot of this is already here. A lot of, for example, municipalities are now experimenting with, using an AI court, if you will, to challenge a parking ticket or a minor traffic infraction like a speeding ticket or something like that, as opposed to the old days where you had to like show up to court, right? And the officer that issued the ticket would have to show up to court, and you'd have an argument there in court. So a lot of this technology is already being used at some level in the court system here in the United States for international audience. Um, as far as AI arbitrators for civil matters, again, in various contexts, the technology already exists. I was at a dinner last year with a gentleman who had developed a tool that he was beta testing to resolve disputes between passengers and airlines. Essentially, in the old days, if you wanted to get your money back for a plane ticket because your flight was canceled or your flight was late or there was some problem with your flight, you had to call up the customer service agent and plead your case and get an argument with them about what you're entitled to. He developed a platform where essentially it gave you a bunch of options. You basically would type in your flight number and the date, a brief description of what happened. AI would review it, and decide whether or not you're entitled to anything. And then it would give you options. It would say, okay, if you'd like your money back refunded to your credit card, we can do that in 7 to 10 business days. If you'd like us to um, issue you a flight credit, you can use that right now. If you'd like us to give you points back, we'll give you not only your points back, but we'll give you some extra points back to use in a future flight as a way to apologizing. Then the fourth option was always, no, I don't accept any of these AI determined outcomes. I want to talk to a human being. And he pretty much said that 95% of the time people choose one of the first three options and they don't go to the actual human being to arbitrate or rectify their dispute. So again, very exciting technology, but again, not out of the ordinary. A lot of different industries and organizations are experimenting with AI to actually resolve disputes from start to finish.
Yeah.
Back to David.
Thanks, Aaron. Yeah. All right. Let's talk about some of the ways that privacy can break down in AI usage. So first is prompt leakage. This is where the LLM that's trained on prior interactions and by providing you an answer may inadvertently expose facts from prior prompts. Now, why do you care about that? Well, if you put information in and it's an open LLM, then that information may be used in responding to other people's prompts later on. And we'll talk about how that can actually be targeted in some ways. Um, Cloud defaults, a lot of these AI tools are integrated to work seamlessly and tie in with what you have on the cloud. For example, if your email is on Gmail, right, that's email in the cloud. And if you've got AI tools that are going through your Gmail to find appointments for you, for example, and put things onto your calendar, or to summarize your emails for you or the like, well, you got to find out what are those AI tools doing and what are their settings and what are the rights in terms of what they're doing with that data later on, because they could be, well, you may be using it for one part of what you store in the cloud. If you've got other items in the cloud, that can be pulled in as well. The data retention policies, it's important to understand what are the products that you're using, doing with the data. What are those improvement settings that they have? That's one thing that they're often, that's a euphemism often used for controlling what is done with your data as a user. Uh, then there's the issue of illusory privilege. That's where you have tools that may not be protected because of having vague terms of service. That is, the terms of service leave open that the information could be shared or utilized otherwise. And court may, if it comes down to it, if court finds out they provided the information to that tool and that it was open-ended as to what that third party could do with it, that may prove problematic as well. And then finally, with the disguised disclosure, this is the idea that it may not be directly quoted to what you provided previously, but it could be utilized in a way that could be problematic. So these are just some of the various ways that the technology creates the actual issues that we see. So let's talk a little bit about some stories that we've seen in the news. Samsung.
Not to
Yeah,
cut you off, but to go back to the previous slide, one thing that
sure.
I
Let me
want to
jump
point out,
out.
and you used the Gmail,
Yeah.
example.
Hmm.
So what even before AI, or whether it's AI or not, we've all heard the term, if you don't pay for the product, you are the product, right, David?
Yeah. Yeah.
So, Gmail is a perfect example. I'll summarize this really quickly. Some time ago, I was in a car accident. I was riding in one of the rideshare providers, right? And the driver reported the accident to the rideshare company as they're supposed to do. And I got in I had my Gmail account obviously attached to my rideshare account. I got an email from the rideshare company, saying, "Hey, we heard you were in an accident. If you're injured, you want to file a claim, here's a claim number. If we've refunded your fare and given you a credit for a future ride, right? Simple as that. I wasn't hurt or anything like that. I didn't do anything with this information, right? But not within 3 minutes after I received that email, did I go to my Facebook page and I was just, scrolling through it, and every single ad that popped up in my Facebook feed were for personal injury attorneys marketing their services to people that have been injured in rideshare accidents. Now, how does Facebook know that I had just been in a car accident in a rideshare service? Why would Facebook think I'd want to sue a rideshare company? Well, I use the free version of Gmail. Every Gmail I send or receive is probably reviewed on some level um, by Google or otherwise, and then information possibly translated, sent to Facebook. And it's the same thing with what David mentioned. If you use the paid service of a lot of these products, um, the paid service of Outlook, there's a paid service of Google. The protections and what they do with that information is a lot more certain, right? So for those of you that are handling confidential case data, things like that, and you're using free Gmail accounts and all that, I don't recommend that.
Yeah. Okay. It's I mean, it happens all the time. That's exactly right. There's those kinds of, that's what the business model is,
And
right?
somewhere in the terms and conditions, when I signed up for that Gmail account, I agreed to all this, right? So
Exactly.
again, you always have to read the terms and conditions.
Right. Okay, so one example, Samsung had a situation where the Samsung engineers started using ChatGPT to improve their source code. And to do that, they took their existing source code and put that into ChatGPT and asked it, how do I add this? How do I add that? How do I improve it? Things of that nature. Uh, it ended up exposing all of the proprietary source code to ChatGPT, and through various techniques, people were able to pull that out. This resulted in a company-wide ban on generative AI, and I think was an early illustration of the potential problems for many in the tech world. Uh, in our case, it could be something where, again, a client could put something in asking for how do I position this case for arbitration or something like that, or how do I draft this contract, and providing information that could be problematic later to have be public. Another instance was Tesla. They have the shadow mode logs. These are internal logs that revealed all kinds of information about drivers and the paths that they traveled, driver behaviors. This resulted in some class action work because when these logs got leaked, and these were being developed for Tesla's AI projects. It showed that by just trying to build the AI product into their regular business can become problematic for you later on, and also can create quite a bit of data that you have to manage that could become problematic other than just the AI tool that you're building. So Meta had some instances where their LLM was subject to prompt injection, and this meant that hackers could provide prompts to the LLM that would get the LLM to provide them with specific data that users had already provided to them. There are techniques, obviously, this is of concern to the AI companies, those who own and operate these LLMs. And so they are working on it, but Meta's was something where there's a large gap for them, and made it easy and created a bit of embarrassment for Meta above and beyond the legal problems. Uh, Ring had an issue through a vulnerability in the firmware. That's the software that's on the piece of hardware. In this case, the Ring camera that you put outside the front door or elsewhere. And there's a facial recognition feature that they had, but people were able to tap into that unauthorized users were able to tap into that through the firmware that, again, that software on the device. And that can create issues because uh, evidence such as that could be potentially manipulated, right? You can't necessarily attest to the chain of custody if it's something where a third party could get into that Ring camera, and that could make otherwise useful evidence useless for your case. And then plugins. So this is big on some of the core LLMs. Plugin is basically the idea of tying in other apps, other software. So it ties various apps together so that they can all benefit from the combined use of the LLM tools. And the issue there is that if the security is not properly set in all of them, it could become a problem for the others. And because of being, it's an open channel. So even if you have a software product that has all the proper security settings, but it's tied in to use ChatGPT, for example, for particular functionality and tie into other apps, if those other apps have security failures, that can then have a downstream effect and taint all of the products that are tying together. Any other thoughts on this one, Aaron?
Well, I just want to say the prompt injection vulnerabilities is particularly interesting. Essentially, hackers or people doing some sort of malfeasance can create bots to flood the internet with any type of information. And, this isn't a slam against open network or open source LLMs, but, ChatGPT, for example, when it's scouring the web for information to answer your question, I think you really should, you can write, type in what are your sources, right? And it'll tell you the sources it got the information from. And if the two main sources the information came from are Wikipedia and Reddit, as I've often seen on some of the searches that I've run, I'd really start to question whether this is an accurate response, right? Because as we all know, Wikipedia, anybody can write anything on Wikipedia, right? It's edited and produced by the people. And in Reddit, people can just absolutely post falsehoods on Reddit. And that's not a reliable source of information. So I think you should really, whenever you're using an LLM for anything, check the sources because these prompt injection vulnerabilities are particularly dangerous when you're talking about things that are open source or open network, right? Those are the ones that are easiest to fool, if you will, to create that hallucination.
Yeah. Okay. All right. So let's talk a little bit more about how some of these issues can crop up. So there's something called a model inversion attack. This is where hackers can reverse engineer the AI. That is data that's used in fine-tuning the LLM can be extracted from the LLM. And if your data was part of that data that was used to train the model, then the model could be providing that, right? It's built into the model. It's a permanent part of that model. Prompt injection is where you have malicious inputs. So that's kind of what Aaron was talking about, the idea that you can put bad information out there. And by doing that, you can then manipulate what the model is going to be providing to you, right? Data poisoning is kind of on a greater level. This is to provide sources to the model that say a particular statement, and so for example, this is something you could use if it were a larger issue, whether a political or some kind of consumer product, and to set an expectation out there in the world, partially by planting news articles, partially by planting fake websites, feeding those fake websites into the popular LLM products. The model is now going to be altered by that data because it's being purposefully retrained on the poison data, right? Um, the training data risk is something that's a risk facing the person that has the information that was meant to be private that somehow was provided to the model. So let's say you have information in some kind of a data room that's NDA bound, and that data room is in the cloud and was included in the sweeping use of the AI product to, hey, look at everything on my computer and tell me about X, right? Well, if you've got access to these other areas, you've now violated the NDA unintentionally, but nonetheless, you've got those issues, and those privacy protections can evaporate very easily. And then finally, the misconfiguring of the tools, even when you're aware of these issues and trying to put the proper settings into place, they may or may not be. And obviously, settings can be changed. The products are developing and evolving, so it's something that one has to stay on top of regularly as you use these various tools. Aaron, any other thoughts on this area?
No, I mean, just like as I mentioned on the last side, I think the prompt injection, the data poisoning are real problems, and just people need to be aware of the limitations of AI when it comes to those things. And again, it's all about checking the sources, right? You have to verify the sources where the LLM is getting the information. If you can't verify the sources, then I wouldn't use the information that the LLM provides.
Yeah, no, that's a good rule of practice. Okay, so let's talk about some of the things one can do. A basic rule is to be using paid products. As Aaron said, if you're not paying for the product, you are the product. This is the difference. You have something like ClearBrief, right, where it's a paid product, where it's particularly designed for this type of use, versus something like the free version of ChatGPT, for example, which is, purposefully they're providing it to you for free so that you will provide it with information, which may be fine. There are some of the AI products I will be using, and I use the free versions. But I'm mindful of the fact that what I'm putting in there is being used to train the model. So I'm running more generalized searches, or I'm having it do a different type of task, but I'm not having it work on confidential product, obviously. So just be aware of that. That's the number one thing, if nothing else. Usually, you're going to have to be paying for the product first off. That's just kind of the table stakes of the conversation to be able to have your data protected. Another big thing is to disable training by default. This is often how these tools are configured to continue to use the data for training, so it builds into the model going forward. You want to turn that off if you have any sensitive information that you're going to be utilizing in that tool. This may or may not be available in the free versions, and often is not, for the obvious reasons. There's a reason that they're providing it for free. Also consider updating confidentiality clauses, including restrictions on AI usage and disclosure during arbitration if you're acting as an arbitrator, even if you're acting as a party. If you're a company, you have those NDAs. Include provisions regarding AI usage in your NDA going forward, right? Just think about these issues. Now, vetting of the third-party tools, we've been talking a lot about that here, but having an understanding and a tracking of which computer and where is using which products and what the data retention settings are of the products that are being utilized. Keeping an eye on all of that. And if you're going to be using AI, if you're an arbitrator and you're going to be using AI for research or otherwise, I would suggest logging that usage so that you can cite to it in your decisions moving forward. It might be a good idea, though, to make disclosures about that. And that goes not just as an arbitrator per se, but also as an attorney in your client agreements, letting folks know what you will be doing and what your practices are. Of course, as you start to use new products, that means it either has to align with what you've provided or updating those client agreements. So that's going to be something to keep in mind. And then there's guidance from the American Arbitration Association, which we can jump into. Aaron, you want to
Yeah, I
take
would
that
just say
one?
before we flip the
Yeah.
side, again, vetting third-party tools in the importance of encryption, but also where the servers are located, right?
Hmm.
If you're dealing with matters of national security or you're a defense contractor and you're developing the operating systems for like fighter jets using AI or something like that, like, do you really want that information going through and stored on servers in countries that might potentially be your enemy, right? Things like that, right? So, um, uh, just a little bit of information, you can often engineer or reverse engineer something, and you really have to think about stuff like that when it comes to betting the location of where the information is being stored.
Yeah. Okay. Okay. Let's jump into it then.
Okay,
Aaron?
so the AAA ICDR issued arbitrator guidance on the use of generative AI. We issued the guidance because we didn't want our panelists just using AI without understanding how to use it, and potentially putting awards in jeopardy or um, making confidential information publicly available. Arbitration is supposed to be a faster, more efficient way to resolve disputes. It's also, in theory, supposed to be a confidential way to resolve disputes, as opposed to having all of your information on some public court record, as most cases are here in the United States. So, next slide. All right, so how is AI being used in arbitration? And David touched on a little of this stuff. So obviously, legal research. We talked about clear brief and things like that, and in finding the best cases to cite your position, as well as to review the cases that are cited in the parties' documents that they send you. Document review, and I'll include e-discovery in that. We all remember, or a lot of us remember, being first through third year associate at a big law firm, and there's going to be a big doc review project, and we basically round up a bunch of junior associates, put them in a room with computers, and hundreds of thousands of pages of documents and emails and whatnot have been scanned into relativity or whatever program you're using, and you're basically going through line by line, reading each line, looking for relevant information. Um, this would take many hours of time and a large staff of folks and things like that, and it's just now a lot of this stuff can be done with the click of a button in a matter of seconds. Language translation it just makes sense. A lot of documents that you might be doing discovery with are in foreign languages. You need them translated to English. Also, when you're taking depositions and things like that, somebody might be speaking in a different language, and you can have live translation. Virtual hearing tools, including transcription tools. We've at AAA we partnered with a company called Optima Juris. They have uh, a virtual, if you will, court reporter that essentially, as the parties are speaking, transcribes what they're saying, and then there is at the very end a little bit of human review to make sure everything makes sense. But it is a fraction of the cost of a traditional human in-person court reporter. Settlement tools, obviously, you know, Westlaw and Lexis and companies like that for a long time have been, tracking public jury verdicts and sometimes mediation settlements that are made public, entered into databases so parties can basically evaluate their case as opposed to what other cases that have come before and come up with a settlement idea. Now AI is getting involved in that. Arbitration clause drafting, and I encourage you all to visit. I've listed two websites here. So we have clausebuilder.org, which is our classic arbitration clause drafting site. Basically, you go through a series of steps and it produces an arbitration provision at the end. We also have clausebuilder.ai, which we're beta testing right now, where I simply would type in a prompt like an LLM. I'd say something like, draft an arbitration provision for a software as a service vendor contract to be heard by a single arbitrator in California, right? Something like that. and it'll actually put all that like in the correct legalese and whatnot, and you'll have a arbitration provision you can do. Filing demands, we're starting to see AI sneak into drafting initial complaints, um, filling out demand for arbitration forms, etc., just basically parsing together information. Drafting motions and briefs, especially, very standard motions and briefs and responsive briefs and whatnot. And then, of course, using it for conflict checks. AI is great at kind of going beyond what you might have just kind of in your initial Excel spreadsheet or wherever you're storing your potential conflict database. And AI can go a step further and say, hey, you know, um, uh, you mentioned you had a case 7 years ago with such and such attorney, but we did a quick little scan here, and it turns out you're also part of the same bar association as them. You may have done a presentation with them on that bar association 3 years ago, all that kind of stuff. I mean, it's pretty amazing what AI can find. Next slide. We came up with some just general guidelines and the parties' expectations and transparency. So obviously the first one is maintaining confidentiality, and then arbitrators must ensure the use of their general use of generative AI does not violate their confidentiality obligations under the canon of Code of Ethics of any applicable arbitration rules. So it's really important, basically, to summarize this for the arbitrators to read the terms and the services of any AI platform that they're using, so they make sure they understand exactly what that information is being used for and where it's going. So as I said before, if you don't pay for the product, you are the product. And as David mentioned, the way around this is you want to use the enterprise versions of these products, and you want to disengage the default settings that are using basically machine learning for the AI program. Next slide. Uh, Competence, right? So if an arbitrator obviously uses generative AI to summarize information or do legal research, you know, it's only as good as the database that it's trained on. And I used the example before of ChatGPT, using Wikipedia and Reddit and things like that as sources of information. And, you know, AI can obviously hallucinate, right? It can create cases, research, statutes, and stuff that don't actually exist. So we always say trust but verify. So it doesn't matter if the LLM spits out a Westlaw citation with a number and the correct number of digits or whatever. It doesn't. I don't care how correct it might look on its face. You absolutely have to check that case site, right, to make sure it's a real case. I was in court a couple of months ago, and it was in small claims court, and there was a gentleman there that had used one of the LLMs to draft his complaint in all of his legal documents, and there were multiple fake cases that the judge actually caught reading through his materials, and the judge actually dismissed his case because he couldn't rely on anything that this gentleman had submitted. And it's tough when you're a pro se litigant and you don't have access to Westlaw or Lexis or something to verify case citations, but there are other free services around it where you can actually do that. Next slide. All right. Fairness. So basically, arbitrators have the right to preserve fairness in the arbitration process. And to the extent an arbitrator obtains legal information from a generative AI tool that could impact the process or decision making, the arbitrator should provide that information to the parties to give them the opportunity to address it. So our advice is if you are using these tools to come up with your decisions in an arbitration, you should document which tools you're using, um, which prompts you're putting in, the date and times that you put the prompts in, and the outputs that came out. So parties would have the right to kind of evaluate that. If an arbitrator gets the case completely wrong because they're relying on information that's essentially the hallucination from a large language model, then the parties have the right to know that's why the information's incorrect, and potentially the award could be vacated. So the parties have the right to examine this information. Next slide. This is really important. So no delegation on duty to decide, right? So I discussed a little bit about our AI arbitrator, and how the AI arbitrator essentially is going to make a decision, and then we're going to have a human arbitrator review the results. Well, the vast majority of arbitrations here at AAA are not conducted by the AI arbitrator. They're done by regular, good old human beings, right? And uh, No, it would be completely inappropriate for you to type into a large language model just basically a large data set or feed in the complaint and the response in an arbitration and just ask the AI who won. That is delegating the decision making to generative AI, and ultimately you're responsible for the decision you make and the outcome of it. So if the generative AI completely gets it wrong, you can't say, well, this is just what the generative AI told me to do. It's not my fault. No, it's your fault. Next slide. All right, so our principles for AI usage are confidence, confidentiality, advocacy, impartiality, independence, and process improvement. And we came up with these in conjunction with, I believe, the Silicon Valley Arbitration Mediation Center and some other groups that we consulted to see if we could have like a cohesive group of rules for the use of AI usage. Next slide. Competence, right? So obviously we want our arbitrators to understand how to use AI before they do it. And if they don't understand how to use it and they don't understand the ethical obligations that surround it, they shouldn't be using it. Confidentiality, as I mentioned, that arbitration in theory is supposed to be a confidential process. So when you're putting confidential information into an AI tool, again, especially if you're not using the enterprise version of something, and especially if you don't understand the terms and the conditions, or you haven't read the terms and conditions of use, um, you're potentially putting folks confidential information at risk. Next slide. Advocacy. We said when using AI tools, an advocate should promote accuracy, expedience, and candor. AI applications with the best interests of clients and justice systems integrity and champion responsible AI use is an essential component of advocacy. We don't want people to be scared of AI. We want our panelists to use it. We think AI can be good for the future. But it's all about understanding how to use it responsibly. Impartiality, obviously, ADR neutrals must scrutinize AI data, and you should really avoid the overuse of a single LLM over another LLM. I know in the legal world, a couple of LLMs, like Harvey, for example, have emerged as leaders in the space. But it's amazing, and I encourage any of you on this call to just do this in your free time. Um, you can type the question into 4 or 5 different LLMs and get 4 or 5 completely different responses. It's actually pretty amazing. So when you don't want to rely just really on one source. Next slide. Independence. So, while AI can provide valuable insights, ADR professionals must exercise independent judgment, right? So we talk about this. You're solely responsible for your work product, right? So you can't blame things on the AI for necessarily getting it right or getting it wrong. And then, of course, process improvement. AI is a tool for enhancing accessibility, efficiency, fairness, and we continuously seek to improve the ADR administration services and related frameworks through innovative applications of AI. So essentially, what this means is we think AI is a good thing. We want people to continue using it and learning about it. We think AI, especially at AAA, we talk about this and it's mentioned in the podcast. AI in the legal space provides, especially pro se litigants, a tremendous opportunity here to not only for it to assist them working on their cases, but to make the system more fair for everybody involved. There are thousands of pro se litigants that file especially consumer cases with the AAA every year. And it can be very challenging for somebody who is not an attorney, who doesn't understand the legal system, to essentially navigate the legal system without the help of some sort of service. And we think AI can be a great help with that. Next slide.
Okay. So I know we're under 10 minutes here, so I think we'll try and be mindful of the time, move quickly here, and perhaps take a question or two at the end. Why this matters, again, we've been talking about attorney-client and work product privileges. You want to protect those, even for non-attorneys. There's many levels of NDAs that are covering a lot of the work that's done these days in business. So you want to be mindful of that as well. Minimizing data leakage. It can be problematic to have information out there above and beyond, of course, the privacy protections that are required from the attorney-client work product privileges or otherwise. You also want to anticipate what's going to be discoverable over AI use and consider those issues ahead of time so you can plan for them. And then finally, in the arbitration context, building trust in that privacy promise, that core feature of arbitration, as Aaron mentioned a few times. I'll touch briefly. There's a lot of activity in the regulatory horizon. I think the area, I won't go through all of these here now, but I think the area where there's the greatest activity is there's a lot of innovation in the states. I've listed three here. There are more that are actively looking at AI related privacy laws. We really could do a whole separate webinar on that alone. So there's a lot of different ideas out there being tried by a lot of different states and various regulatory jurisdictions. And so it's a very active field and something to keep an eye on, or to have someone keeping an eye on, because it could be something that pops up in one state, but that has implications for your whole business because it's difficult to segment your business off at the state line. All right. And so in terms of for arbitrators, what we can be doing are, raising the issues proactively in case management conferences, issuing standard disclosures. This is something I do myself regarding my use of AI tools and what I will and won't be doing and what I expect parties to do and to not do. I'll encourage folks, I encourage everyone on here to think about how to integrate it into your confidentiality protocols regarding what you're doing with AI. That's, requires update as things change, but I think that that's useful. And then trying to stay up to date on these AI matters and the evolving guidance. And with that, we do have a few minutes left here for questions, if there are any.
And I just wanted to add another
Yeah,
thing.
please.
We talk about process improvement, and this is something that I don't know what to make of it. I'm just looking at my phone here. There was an article that came out in Bloomberg Law just this past October, and it said that 94.8% of in-house counsel report no reduction in billable hours from outside counsel's use of AI. And what's even more troubling than that is because AI was supposed to make things more efficient, essentially lower your legal costs, right? We're now discovering that there are a handful of law firms out there that are even pushing back against this, and they're saying, okay, we now admit to using AI for some part of the legal work that we do for you, but not only are we not going to charge you less because we're more efficient doing it, we're still going to have the associate or the partner bill the same number of hours they would do without the AI. And then we're going to charge you a premium to subsidize the cost of AI because we're going to use AI to check that partner or that associate's work. So, it's a little bit sad to see that right now AI really isn't necessarily lowering the costs in the legal world for folks. But the hope is that eventually that it will. Our president and CEO Bridget McCormick has always said that, AI won't replace arbitrators and attorneys. It'll just simply replace the arbitrators and attorneys that don't use it, right, or aren't willing to learn how to use it. But I think we're still kind of early in the infancy here as far as finding out ways that it can actually reduce costs. I don't know, David, if you had a thought on that.
Yeah, no, I think on a broader picture level, I think it's akin to email, right? When email first came out, remember how email works without getting into all of the details is essentially your computer hands off a message to another computer and a series of computers until it gets to the recipient or recipients, right? Well, all those computers have a copy of the email. And at first, this created a lot of consternation in the legal world about, was this breaking attorney-client privilege? Was this breaking other non-disclosure agreements and the like? And eventually, we got comfortable around it with an understanding of what can be done and what can't be done. Things like, both people understanding what to put in email. Well, to some extent, I think some are still learning that lesson, but also in terms of encrypted email and other various features and products. And so I think we're going to get there. It's just going to take some time for everybody to get familiar with it. But to the point that Bridget McCormick made in her quote that Aaron just cited there, it's about staying on top of it, because if you have an understanding of these tools, then it's easier and you can avoid having the problematic situations.
All
Uh,
right, all right. We have a little bit of a question here. Excellent summary. Thank you, Lars. Would it be possible to get a copy of the slides? Will production of documents increase as a result of AI? The first question in the slides, I guess we could send them to iTech and they could forward them out to folks. David, if you have
yeah,
a thing
I
about
can do
that.
that. I can send the
Sure.
So,
deck.
okay. Um, will production of documents increase as a result of AI?
Yeah, I mean, I say absolutely. Uh, I think just the volume of data out there in the world is increasing exponentially. I saw a statistic somewhere that is currently estimated. Forgive me, I can't remember where exactly I saw the source, but that just under half of the web pages on the internet are AI generated.
Yeah.
Um,
Yeah.
and so, I can't test the veracity of that since I can't even remember where I saw it exactly. But I think that feels directionally correct. That there's a lot being created of data and of new data, and because AI can synthesize information and provide a summary. If you think about it, if you have an AI tool that's summarizing your emails, you have the original email, but you also have the summary. So now there's two documents off of that email, right? You've just doubled the number of documents that may be relevant and to produce. So I absolutely foresee that field growing tremendously.
I just also put a link into our
Yeah,
AAA AI podcasts. Again, we're doing a lot of exciting space stuff in the AI space, and a lot of these podcasts will give you a better idea of what we're working on. All right.
yeah,
Well, thank you all for all the nice comments. Thank you, Cynthia, and Tina. If there's no other questions, I guess we're right about at the hour.
yeah. Thank you everyone for your time. Really appreciate it. And if you have any questions, feel free to reach out. Uh, I think our contact info will be in the slides, but you can reach me at Coher ADR, Coher ADR.com, and
Well,
happy to be of help.
yeah, and thank you all for joining, and thank you to iTech for helping us produce this and put this on. And we'll see everybody down the road sometime. Bye.
Take care. Thanks.
Thank you, Erin and David, so much for the webinar today. And as a reminder, this has been recorded and will be available on iTech Law's YouTube channel, probably in a business day. And yes, we can make sure those slides are available to folks to download and check out as well.
Great.
See
Thank
ya.
you.